Good afternoon. So welcome to the panel on economics in antitrust. My name is Philip Kalmus, and I'm a vice president at CRA, and I work largely in antitrust litigation, mostly damages litigation. Now, I named our panel from more economic approach to which economic approach. Overall, I think it's fair to say that in Europe, there is a big shift to modify the economic methods and tools used in abuse of dominance and cartel cases. In the DMA, we find the basic concepts of market definition and dominance being replaced with simpler metrics, such as user numbers, and we have simpler concepts of gatekeepers. We have the Commission's renewed attempt to write guidelines for Article 82 based on the learnings from its own cases and from the decisions of European courts, which will also result in new economic concepts. In cartel litigation, I can sense skepticism by national courts to listen to detailed economic and econometric evidence and replace it with the use of damages presumptions based on simple indicators, such as the coverage and the length of a cartel, or in the case of the UK, with the broad brush, the use of a tribunal's independence to assess damages based on their own broad assessments of the case. I'm very curious to hear the perspective of Paula Blizzard from California to see if also there is a similar shift in economic tools in the US. So in sum, there appears to be a move away from seeing the main use of economics in the detailed analysis of a particular case to a type of reformed form-based approach in which presumptions are established on the basis of economic insights. So we come up with some form of an effects-based per se rules method. Is this the future? Is this what's happening? Is this hypothesis correct? If yes, why is this happening, and is it a good thing? So in our panel, we want to step back and recapitulate what's going on with economics in antitrust, where we come from, where we're going to, and how the role of economics is changing. So let me present our speakers. To my left, we have Lindsay McCallum. She is the Deputy Director General for Antitrust in DG Competition. She joined the Commission in 1995, and she is one of the key driving forces in DG Competition in the drafting of guidelines for Article 102. We have Paula Blizzard. She's the Supervising Deputy Attorney General for Antitrust in the state of California. Fascinatingly, Paula previously had a career in aerospace as a NASA contractor working on space station design on NASA's early use of the internet. Then we have Kai Thomas Brauneisen, who's a judge at the Regional Court of Mannheim, currently seconded to the German Bundesgerichtshof, the Federal Court of Justice. And he was the judge in a landmark German damages litigation, the sugar cartel, with the judgment handed down earlier this year. And so lastly, we have Volker Nocker, who is professor of microeconomics, specializing in industrial economics at the University of Mannheim. He was previously professor of economics at the University of California at Los Angeles, and prior to that at the University of Oxford. Okay, so Lindsay, we're going to hear from you first. And I ask you to speak on the evolution of economic thought in the Commission's thinking from the more economic approach phase through to the new attempt to draft guidelines for Article 102.
Well, thank you very much, Philip. And it's a pleasure to be here today as a humble lawyer and to take part in this discussion. And as you say, it's a vast topic that you've set out for us, and I'm going to look at it through the prism of the initiative that we announced in March to work towards guidelines in the field of exclusionary conduct under Article 102. And really, from my perspective, if we think back over the last few years, I think that's one of the most important policy initiatives in the 102 space, certainly since 2008. And it very much reflects our attachment to keeping this instrument effective and alive in view of all the challenges that we face in the future. So I'm going to talk about three things. I'm going to talk about what we've learned since the guidance paper in 2008 in moving towards an effects-based approach. I'm going to talk about the reasons for why are we doing this now in terms of a 102 initiative and what do we want to achieve by it. And last but not least, what do we see as the role for economic analysis in this process? And I can already reveal the spoiler, we think it's important. So for those of us in the room who were still working on these topics in 2008, you'll remember that the guidance paper was part of a much broader initiative to increase the reliance on economics in EU competition law. Prior to that, prior to the initiatives that started probably with the vertical block exemption regulation reform in 1999, we had a fairly form-based approach to the assessment of agreements and to conduct. So the guidance paper was part of a broader initiative, but I think it had some fairly specific and special features. In particular, it wasn't a statement of the law. It was a very conscious attempt by the Commission to shift the dial in terms of the court's jurisprudence and what is necessary to prove an exclusionary abuse. And in that sense, it added requirements to the case law that existed then. So a lot has happened since 2008, thankfully. The Commission has been, I would say, a very active enforcer in terms of exclusionary conduct under Article 102. Some 26 decisions have been adopted in that time period. We've seen 33 judgments of the courts in Luxembourg, including important preliminary references, because this is an area where national competition authorities have also been active. And the reality is that today, the effects-based approach, the more economic approach in its principles, is firmly ensconced in the court's jurisprudence. Of necessity, and I think that's a good thing, the Commission is fully committed to an effects-based approach. The guidance paper was critical in terms of shifting that dial, and there is simply no going back. But I think it's exactly because of all the experience we've gained through the jurisprudence, all the experience we've gained through our own enforcement work, that we thought the time was ripe to launch a more public debate on the principles and the issues that are relevant to exclusionary conduct assessment under Article 102. Because let's also not forget that this is one of the very few areas of EU competition law where we don't have full-fledged guidelines. And I think the time is ripe to remedy that. It's also true that the preparation of Commission guidelines is not a fast exercise. And that has two reasons. One is substantive. This is a complex area of law and economics, and I think it merits the time and discussion with our stakeholders, with our national competition authorities to get it right. And then there are also procedural constraints. So that's why back in March we didn't want to just set out the future, we would like to have guidelines. We already wanted to amend the guidance paper on the issues where we saw the largest disconnect between its terms and our own enforcement practice as reflected in the case law. I think that's good practice. It's an issue of transparency, it's an issue of good administration. Even if, of course, the guidance paper is destined to be withdrawn as and when we are ready to adopt guidelines. I think what we've also seen from the various conferences in which these issues have been discussed is that the amendments to the guidance paper have been a helpful way in kickstarting the substantive debate. Because after all, some of the changes that we made are on fairly fundamental issues, like the standard of intervention or the use of quantitative tests. So we can come back in more detail to that in terms of how the discussion develops. In terms of what Philip posited as the basis of this panel, I think what we can say today after all these years is that the debate is not about whether we want an effects-based approach, it's what does that mean in practice? When we run an effects-based case, what does it actually require us to demonstrate? And it was in search of that greater clarity round about what effects-based approach to exclusionary conduct means. That was one of the main reasons why we thought it was time to move towards guidelines. I think it's also fair to say that, we have a very rich jurisprudence that has developed from Luxembourg since 2008 also. It's rich in the sense quantitatively, it's also qualitatively quite complex. So another reason why we thought guidelines make sense is to look to take stock, to systematize, perhaps in some respects to clarify aspects of this complex case law that has developed over the last few years. And I think that will be valuable for everybody. It will certainly be valuable for enforcers. I think it will also be valuable for companies, for their advisors. I think there is a value to the legal certainty brought by guidelines, which will also have the helpful counter effect of providing greater transparency on the Commission's own enforcement practice. So this is not the day to get into the details of what the guidelines will contain. We are working towards publishing a draft for public consultation in June of next year. But I can already give you some indications today of our direction of travel. And I think the first point is that if we really want to live up to the ultimate goal of having guidelines, if we want to bring clarity to the relevant legal framework and give clarity on the Commission's view of what effects-based analysis means, then we should start these guidelines with a general analytical framework which is relevant to the analysis of all exclusionary conduct. In other words, a principle-based introduction. I think that is important also to make the guidelines relevant in terms of conduct that we haven't yet encountered. So important in terms of making them a little bit more future-proof. And that will inevitably require us to get into some of the interesting concepts that have come up in some of the recent case law from Luxembourg, like what competition on the merit means. We see from the jurisprudence how critical that concept is. A dominant company whose conduct constitutes competition on the merits, by definition, cannot be abusing their dominant position. But at the same time, I don't think the court is asking us to revise and review the totality of its jurisprudence over the last decades. In other words, if we have a specific legal test for a specific form of exclusionary conduct, I don't see a need on top to demonstrate that that conduct doesn't constitute competition on the merits, for the simple reason that that concept is hard-baked into the legal test itself. I think the other thing we want to do with guidelines is to be as operational and practical as possible. So not only will we talk about all the different types of abuses, I think that we've had good experiences through the horizontal and verticals exercise in terms of using case examples, and I think that's a way to make the guidelines as operational as possible. So I'll end with a few words much more specifically on the role of economics in this process. We are not moving back to any form of formalism, just to respond to Philip's introductory remarks. I think even if we wanted to, we couldn't, because the court has told us that we're working in a world of an effects-based approach, and I personally think that is very, very positive. Economics has been very useful to us over the years. There's one very simple reason for that. The court tells us repeatedly that we need to look at any conduct in its economic and legal context. That conduct that is pro-competitive in one set of circumstances may be anti-competitive in another. And in my experience, it's working with economists that helps us to understand the circumstances in which conduct is more likely to lead to harm, and indeed even to lead to a typology of types of conduct which on their face are more likely to be harmful. So I think it's important to say that, to our mind, an effects-based approach doesn't mean a fully open-ended, case-by-case approach where we have no priors. I think where economics helps us is to categorize the risks that are inherent in different types of conduct. I think it can help us understand trade-offs in terms of the benefits of legal certainty as opposed to false negatives or positives. And I think in that sense, it's fully in keeping with sound economic principles to work with the rebuttable, and that's important, it's not per se, the rebuttable presumptions that the court tells us are relevant in terms of exclusionary conduct. Just think of the meeting of minds between the judges in Luxembourg and most economists on the very likely harm through exclusive dealing, for example. So the assessment of different types of conduct, those which are likely to be more harmful and those for which a specific legal test exists, I think that may well imply that there's a lesser need for super sophisticated economic analysis for an enforcer to bring forward a case. And the corollary, of course, is that where no test exists, where there are no presumptions, that's where we have to go the extra mile. And I think as we think about drafting the guidelines and our work in the months ahead, I think these dual concepts, on the one hand, of rebuttable presumptions and a sliding scale, if you like, of the evidence that we need to adduce to bring a case forward in light of the severity of the potential exclusion that a conduct might cause, those dual concepts are going to be important to us. Since 2008, I think maybe one of the principal areas where we've learned about the use of economics is in terms of quantitative tests. Obviously, those can be super informative and very meaningful. If you think about simple price-cost tests in predation, in terms of telling us that a dominant company is pricing below its costs, is sacrificing profits, that leads to a presumption that its pricing conduct is likely to be exclusionary. But I think there are many circumstances where these price-cost tests have demonstrated themselves to be anything but simple. Think about all of the discussions around the contestable share and rebates. And it's also the case that in many circumstances, these quantitative tests are not particularly helpful in distinguishing anti- and pro-competitive conduct. I don't think it's super important in an exclusive dealing context whether the dominant company is actually pricing below cost. And this, again, I think is consistent with what the court has told us. The court has told us that price-cost tests are optional in terms of rebates and don't look to be particularly useful or appropriate in terms of non-pricing conduct. And so the guidelines, I think, will build on and provide further clarification on the use of quantitative tests. But I wanted to end on an absolutely positive note, which is where I think economics is helpful in all respects in our enforcement work and in our engagement with private bars. And that is in terms of the development of theories of harm. I think economics has a very valuable and useful role to play in helping us understand the mechanisms by which conduct can lead to exclusion. I think that is helpful in terms of the narrative of our casework. It's also helpful, frankly, in terms of making us think about what is the evidence we need to collect to bring our cases forward. And that is a point which, whether it's in the guidelines or, frankly, in our enforcement work, I'm looking forward in the future, as in the past, to working closely with our chief economist colleagues. I could talk more and more, but I will stop.
Thank you so much, Lindsay. Just a very quick follow-up. So with your experience, I said since 1995, you've seen these two phases, the formal approach and the more economic approach. Do you think the more economic approach has led to less or more enforcement actions?
That is not a question that has a quantitative answer, because I don't think it's just a question of how many decisions happened prior to 2004 and how many decisions happened afterwards. I think what I'm fundamentally convinced of is that we now run more meaningful cases that it makes sense to do compared to the times when we used to live in a much more formal world. And I like the fact, Philip, you keep emphasizing how old I am. It's true. And, when I started in DG competition, which is a while ago, one of the first cases I dealt with as a case handler was a notification from 20 years previously on a provision of the UEFA statutes. And that kept me busy for a couple of years, and I can tell you that was entirely pointless. So I have no doubt that the work that we do now is significant and meaningful, and that the fact that we look at the effects of conduct on the market has an important role to play in making sure that's the case.
Thank you. I have to remind the audience that you started in 1995, because otherwise they wouldn't believe it.
Ah, thank you. It was actually 1993, so it gets worse.
So thank you. So let me move to Paula. So Paula, from the Californian perspective, well, I note first that you're litigating against Google. And so you've seen here that there is the additional regulation, like the DMA, in Europe. So I'm wondering if you think that that is needed in any way, and also, why it might not be needed, and whether any economic assessment plays into your opinion. And But perhaps you have other concerns about the use of economics that you might want to discuss. Now, just one other point. Since we've got the great privilege really to have someone here from the birthplace of big tech,
yes,
I'd just like to give you the chance to comment on this general view expressed today that the DMA's aim is to foster innovation. Because when you sit in California, the pace of innovation must be absolutely mind-boggling and is probably higher than we've seen in our lifetimes. Just thinking of the latest innovation in large language models like ChatGPT. So it feels like the future has arrived. Okay? So I'm curious on your perspective of that European view that we need to foster innovation. And perhaps instead you can tell us what you are trying to achieve when litigating against Google.
Absolutely, thank you. There's about 1,000 topics in there. Well, thank you to CRA for inviting me. It is a pleasure to be here. It's a pleasure to talk to you about the California economy. I do feel like you were talking about it all morning without saying it, because obviously we have Silicon Valley, we have Google, we have Apple, we have Meta, and all of their many companies which play an incredible, important role in each of your lives every day, I would imagine, unless you don't pick up your phone or use the internet. So for instance, we have 3 lawsuits against Google. Why would the California Attorney General be suing its own company? I get this question. I also get the question, why would a state have an antitrust program? So let me just remind folks that the California economy is the same size as Germany. You would not ask Andreas Mundt if he should have an antitrust program. So we do too. And so we are just like Germany, only perhaps better weather, more coastline. But our goal very much is to foster innovation. We are firm believers in innovation. You come to Silicon Valley, you come to San Francisco, where OpenAI, ChatGPT are. It sometimes feels like it's in the very air you breathe. It's a little foggy sometime in San Francisco, but it's still, innovation is in the air, and so my job is to protect that. But that does not mean I protect entrenched monopoly power. In fact, it's the opposite, right? In 1 year, 5 year, 10 years, I still want the EU and the UK to be worried about those California companies, okay? I don't want them to be the same companies. I don't want it to still be Google and Apple and Meta, right? I want innovation to be on their heels every minute of the day, turning it over to be some other companies. But we want very much that innovation to foster. That is my job. And sometimes that means my job is suing Google or Apple or Facebook or Amazon or many other companies, even outside of tech. Let me talk a little bit about the role of economics in US law. And Lindsay was just saying we're never going back. And I'm here to say I think we need to go back. Particularly in the US, I think we overshot. I think we overshot the mark, and we have too much economics. And so let me see if I can advance my slides if I hit this button. Ta-da! Okay. So I'm going to talk a little about federal law and state law. We have both. A lot of what's up on is for those of you who are devoted enough to want to get some case citations. You can find them all here. But so let me start with a quote from President Biden from July of 2021. We're now 40 years into the experiment of letting giant corporations accumulate more and more power. I believe the experiment failed. Okay, so that's a quote from his speech, and he was speaking, as you all know, about really the consumer welfare standard and the rise in the 80s of a much more economic approach. And so at this point in the mid-2020s, I think the view is that we overshot. My view is, California Attorney General's view is, that we have too much economics. And I like to bring people back to the Sherman Act, which is below that and is quoted. And this is what the act actually says, okay? Every contract in restraint of trade is a felony. Okay, so every contract in restraint of trade is pretty much every contract ever written, because that defines a contract. It has to somehow restrain trade. So it can't mean what it says. And at the same time, it was supposed to be a felony, as was every monopoly. When these laws were written, they were not thinking you needed a hypothetical monopolist test. They were not thinking you needed a relevant market or cross-elasticity of demand or balancing of anti-competitive and pro-competitive benefits, right? There were no economists in sight when the US Congress laid down this law and said, this is what you, both federal and state enforcers, we also enforce this law, are supposed to be prosecuting, right? So I'm not saying we should go back to the days when every single contract is a felony, but I think perhaps we need to consider whether we've overshot the mark. And this is really what I think President Biden was saying when he said that the consumer welfare standard, as applied in the United States, where we are today, incredibly conservative, that this is not what was intended, and this is not what is good for the economy. So let me give you a couple of examples of some things that we're doing in the US. We, the states, are often with our counterparts at the US Department of Justice on cases. So one of those is our case against Google about ad tech. And what I wanted to say about the ad tech case is it's a jury trial. So one of the ways you break free of a very conservative court regime and a series of decisions that narrow and narrow and narrow and narrow the government's chance of winning is you say, I'm going to give it to 12 random people that came in off the street. Okay, so I know nobody else in the world has this system, but we do, and we love it. And it comes down to a lot more basic concepts, and it maybe comes back to those things that the Congress was saying when it's a felony, which is to say it should be obvious that a crime was committed here, that this is a problem, and that people can look at Google and say, you're a monopolist who is cheating, right? And they don't need a 500-page economic report and 1,000 footnotes, which nobody ever reads, to get to that point, right? Okay, so a jury trial, it's also much faster, which I think is much more suited to tech. We will get the ad tech verdict within days of the trial. In contrast, the Google search case, which we just did, took 3 years to get to trial, and then it's a 10-week trial, 500 pages of findings of fact proposals from each side, so over 1,000 pages in the spring, and then a decision probably a year from now, right? We will get the ad tech verdict sooner. It may be right, it may be wrong, but we will get an answer. Okay, let me talk a little bit about Utah v. Google. And this is a case that is only the states. So it's Utah et al., and California is one of the et al.s, one of the lead states. And we brought this suit concerning Google Play, which is the Play Store. A lot of you know there's concerns about monopolies in Play stores and whether they're imposing excessive pricing or monopoly rents and controlling the apps. We have settled the case, and I cannot give you the details, but I can tell you that it was 53 jurisdictions in the United States, all 50 states and 3 territories, DC, Puerto Rico, Virgin Islands. And you should ask yourself, what do all those jurisdictions in the United States agree on? Healthcare? Climate change? Pick your topic. There are very few things that many attorneys general in the United States agree on except antitrust. And they all agree Google was a problem. They all agree that the Google Play Store was a problem. And I raise this in part because if you think this is a Biden thing, or the Google search case was brought under Trump, so it's a Trump thing, or whatever thing you think it is, I encourage you to think differently. It's not. And the 53 attorneys general who got together on this settlement and agreed on things, I think is an example of that. One other thing I want to point out, we've submitted an economic report in that case saying that harm to innovation was in fact quantifiable harm. So everyone's like, well, yeah, duh. But it turns out in US law that that's a lot more controversial than you'd think. It shouldn't be controversial, okay? Harm to innovation is harm. We've been talking about innovation all day so far. So a challenge to my economic friends out there, go work on this. Help me be able to prove to a court that harm to innovation is harm. How do you measure it? Google said it was emotional. Like, that was part of their defense, right? That it can't be quantified. It's like this amorphous thing. We believed we had an economist, and we had an amicus in support from some other great economists saying it's actual harm that should count under U.S. law. So my charge is let's work on that. Let's get some more quantification of harm. I'm going to go on now and talk about state law. Did you know California had state law? Okay. State antitrust laws. We don't follow federal law necessarily. We can, but very often we do not. So I have the incredible luxury of going with federal law and going into federal courts, or going with my state laws and going into my state courts. And the California State Court, this will surprise no one, the California State Court and the California Supreme Court are perhaps a little more liberal than many of the federal courts that are out there right now. So one of the things that the California State Supreme Court has said is that the goal of antitrust law is to maximize deterrence. And that false positives, where you essentially reward someone who didn't really suffer any damage, but they get a bunch of money, right? A plaintiff gets some sort of windfall, is not so bad. And in fact, those sort of false positives, it is better for the economy as a whole to maximize deterrence and take the occasional false positives rather than have under-enforcement and false negatives where you are letting things through that should have been challenged, okay? So I take this as a personal direction from the California Supreme Court to maximize deterrence. My challenge to the economists on this, help me do that. How do you quantify deterrence? How do you measure the effect of deterrence, right? I bring one big case. I bring a case in one area. How can I say that that matters and that's important to the markets? So studying deterrence would be terrific. I want to mention California's unfair competition law. This is a law that specifically is designed to cover conduct that violates the spirit or policy, but not the letter of the antitrust laws. It is designed to be broader. The quotes up here are some great ones that talk about catching everything that runs the gamut of human ingenuity and chicanery. It is the type of law that can be used to go after any type of tech. It can go after AI. It can go after anything new or different. I don't think fundamentally that the law is our problem, because we have these very broad laws, and we have them in California. And then let me just wrap up with one more thing and a quote from, this is the United States, as California was also on that complaint with the United States, against American and JetBlue for the Northeast Alliance. And the judge in that case was extremely critical of the defense economic experts. And what you see in a lot of US courts is that sometimes the judge just throws up his hands and says, I got brilliant economist A and I got brilliant economist B, and they disagree with each other, and I don't know who to believe, so I'm believing none of them, right? They just throw up their hands and walk away. Other times, like here, he looked at these judges and thought they were biased, and he threw them out, basically, right? That he viewed them with extreme skepticism because they had done a lot of work for the airlines before. They had done a lot of work on the defense side, and they acted more like lawyers in the courtroom, more like advocates, right? They had a side. And that was one of the reasons why he completely discredited their testimony. So I think there is backlash against the economists in a lot of US courts. I think it's something that you need to be very careful about. I would say, you know, my suggestion to the economists looking at these quotes is integrity above all else, okay? I know it's tempting. There's a lot of money to be made to be a defense economist, but there are a lot of risks as well. And I think overall in the US, I think we have overshot. We have too much focus on economics, and I think we're gonna swing the pendulum back the other way.
Paula, thank you so much. Very provocative. And I have a lot of questions, but unfortunately, we should move on. But you've also provided the perfect segue to Kai Thomas Brauneisen. So let me just introduce him a little more. So in January, this year he presided over a week of court hearings in the German sugar cartel, which I'm sure will become legendary in the German competition community, because he kept us in court every day from 9 in the morning to about 10 o'clock at night. And he wasn't afraid to spend many hours slowly and thoroughly going through minute details of economic arguments and econometric specifications. And so I think this is a perfect response, or perhaps a different perspective to Paula. So I'm curious to hear from him as a judge, how he sees the role of economic evidence. Thank you.
Yeah, thank you very much, and thank you very much for the invitation. Like you mentioned, I'd like to add kind of the private enforcement perspective, and more precisely the handling of cartel damage cases by German courts. And status right now is that German and you could also say all European courts are kind of flooded with economic and econometric evidence in cartel damage cases. I think the status quo can fairly be described as a battle of the economic experts as we see it right now. Usually both of the parties would submit detailed econometric private expert opinions, usually the claimant side arguing in favor of damages between 10 and 20%, whereas the defendant side would argue the data they analyzed shows no significant damage at all. And as a judge, especially in Germany, this can be pretty challenging because I'm not sure if everyone knows that, but on a German bench there is no economic expert, so we are all lawyers there, and so if we try to evaluate these expert statements, we need the help of a court-appointed economic expert, which we usually use, but also with the help of such an expert, proceedings take years right now. I think average case, first instance in Germany, lasts between 3 up to 5 years, and proceedings are pretty expensive for the parties. I think you can easily speak about 6-figure amounts just for private and court-appointed economic experts. So I think it's not really surprising that right now there's a huge discussion going on about efficiency and about how proceedings could be made faster and cheaper for the parties. And I think you are right. I think there is a general trend there towards less detailed and more superficial economic evidence, you could say. So right now, 2 main ideas exist. I think the first one tries to doubt the evidential value of econometric and economic evidence. The rationale goes a bit like that. Like all econometric evidence is based on certain assumptions, and so the value is small at best. And a second idea is to introduce the irrebuttable presumption on the size of damages, which, to be honest, in many cases would lead to exactly the result you would write in any law. My personal view on this is, I think right now it is still too early to push back detailed econometric and economic evidence in cartel damage cases. And I think that might also be a different standard maybe than in one or two cases. In cartel damage cases, you only have this backward-looking method, and you also have the task to quantify the harm which was induced by a specific cartel, and especially the quantifying aspect is, for me, really difficult without any case-specific economic or econometric evidence. If you only have to talk about the question whether there has been any kind of harm, it might be easier. And if you're forward-looking, you might not be forced to answer the question at all. But in cartel damage proceedings, I think we should not push back this case-specific evidence too much, because we might need it in the future, at least in many, many cases. And in my personal view, I think alternatives are pretty scarce. Right now, a pretty popular alternative discussed meta-analysis. As I understand, all the economists, I think meta-analysis are not really well equipped to serve as a basis for estimating a specific dimension of damages. I think the databasis of this meta-analysis is just too heterogeneous to estimate like a specific dimension. So I'm not sure whether those meta-analyses, as they are now, can help us quantifying damages. And also, you were talking about more abstract economic methods, a bit like structural arguments about duration of the cartel or form of the cartel, also like legal theories of harm and no harm. Also there, I think, these categories of economic evidence are maybe in many, many cases just too abstract to point you into a specific direction when you need to quantify the harm suffered by a specific party. So right now, I think in many cartel damage cases, we need case-specific economic and econometric evidence, especially empirical evidence, in order to estimate damages. And from my personal point of view, that's the reason why I think we should actually more discuss about what can be improved with handling of this specific evidence. Of course, on the court side, there is obviously some space for improvement. I think we are, especially in Germany right now, we are learning a lot. The field of cases is pretty young. I think the new development started in 2018, so experiences are pretty young, and we have a steep learning curve, and I think there is quite some space for improvement. But and I can elaborate on that later if you're interested, but I think what might be more interesting here is what could maybe improved on the economist side. And I think there the elephant in the room is bias. I think the major reason why people try to push back the meaning of private economic evidence in cases is potential bias of this evidence. And one idea, in my opinion, could be, in order to tackle that, could be to find kind of a standardization of private economic evidence in those cases. And I think the ultimate goal needed to be that this evidence is as transparent as possible when it comes to methods. I think private economic evidence has to show the basis it stands on, like mathematical equations. They have to show the mathematical equation. They have to show the data they are based on. They have to show even the programming when it comes to statistics programs, and also they have to point out all assumptions they're based on and the reasoning why they take certain ways. So I think that would facilitate it a lot for courts and court-appointed experts, but also like for opponents to understand the reasoning and to identify the main issues of a case, and could also help to at least prevent bias and or at least help the courts identify bias, because the alternative always is that if you don't trust private expert opinions, you won't take it into consideration. That's just the alternative. Like I think it's also in the best self-interest of economists to get closer to best practice, maybe. So summing up, I think we really need case-specific, detailed economic and especially econometric evidence in cartel damage cases, but I think it should remain a case-by-case assessment. You wouldn't need the most complex regression analysis in a simple case. I think in some cases you could work with simple average models, and in other cases you could refer to regression models. So I think it should remain a case-by-case assessment. Thanks.
Yeah, thank you very much, Kai. I thank you very much also for the very constructive suggestions. I think we might come back to this if we have time for a discussion. But I'd like to hand over to Volker, and I think it fits also quite well because I asked Volker to discuss from his perspective as an economist, the only economist on the panel, what actually is the role of economists in antitrust competition policy in general. And then I actually also asked Volker to elaborate on a second point, which is whether there is also a gap between academic economics and the economics used in the practice of competition cases. So I'm curious to hear his views. Thank you.
Okay, yeah, thank you very much for having me as the token economist here on a panel on economics in antitrust. Before actually answering Philip's question, let me just make a very cheap shot at Paula, sorry. It's, I find it slightly sort of ironic that, liberals, I think, liberals rightly, and in my view, rightly sort of criticize the originalist approach to legal interpretation of the US Constitution and other historic laws, and now, and I think it's wrong, right, what these conservative judges do, but then I'm not so sure whether, originalist approach to historic antitrust laws is necessarily, sort of then the cohesive, coherent answer. Anyway, so what is according, what do I view as the role of economics in antitrust? Well, I think in my view, it's actually very simple. It's to provide a story which can be theory of harm, or it could be an efficiency defense that is firstly internally consistent, and secondly then points to the relevant facts of the case, and therefore, in a sense, makes that story falsifiable. Recently I've come across a very nice example of that. It's a decision of the European Commission in the Amazon MGM merger case, where in the decision the Commission very logically lays out an internally consistent theory of harm, according to which Amazon, after the merger with MGM, would leverage its increased market power in the AV content value chain to strengthen its dominant position on the market for the provision of marketplace services. That entire theory is laid out in the decision on just half a page, logically, first with various steps. Then I should admit it's later in that decision actually dismissed because a key step in the theory is shown to be inconsistent with the facts. But the important thing is, all I want to say, I think that consistent theory, laying it out and what the steps are, and what would be the facts that you would need to check whether that theory is actually relevant or not, I think that's sort of at the core of what I view as the economics approach to antitrust. Of course, in checking these facts, empirical methods involving, for instance, computing diversion ratios or UPPs and the like, plays a central role. But emphasizing the key role of economic theory and empirical or econometric evidence is quite distinct, in my view, from the role of quantitative tests of anti-competitive behavior. And in fact, one of the questions Philip asked me, actually he mentioned that, is, what is the role of tests? I think some simple statistics or tests using readily available data, for instance, using market shares, can indeed be very helpful, especially at the screening stage. But a theory of harm can rarely, if ever, be condensed into whether a single test is being met or not. In fact, I think focusing on a single test often runs the risk of diverting attention away from the facts or the economics of the case. And let me just illustrate this. I think it's sort of the perverse effect of focusing on a single test, was there in the Intel case, where ultimately the entire case, evolved around whether the AEC test, the as efficient competitors test, was met or not. And, that test, might perhaps serve as a benchmark, but it's whether the test is met or not is neither sufficient nor necessary condition for anti-competitive behavior of a dominant firm. For starters, it could be, that below cost pricing, might make sense because of learning by doing. So might not necessarily, signal anti-competitive or exclusionary intent. But at the same time, even exclusion of a less efficient rival actually hurts consumers, and I think is an instance of foreclosure. And moreover, it's even conceptually not clear what as efficient competitor really means in most cases where firms offer differentiated products. What exactly do you mean by foreclosing an as efficient competitor who's offering quite different products? So I think, it's really whether or not that test is met is, in my view, in this Intel case, as in pretty much any other case, rather, sort of arbitrary. And, I haven't yet met the economist who wouldn't say that in this Intel case, clearly Intel behaved anti-competitively. It was an abuse of dominance, and independent of whether that test was met. Okay, so now let me turn to the, examples that was asked for of sort of gaps between antitrust practice and academia. And one thing that came to mind is when you think about the economic models of vertical foreclosure, roughly speaking, there are two strands of the literature. On the one hand, there are models that evolve around the raising rivals costs argument, starting from a seminal paper by Ordova, Salona, and Salop in 1990. So these kind of theories or models essentially, think about, vertically integrated firm which, faces a downstream rival, and that downstream rival is, supplied by the upstream affiliate of that vertically integrated firm. That upstream affiliate of the vertically integrated firm would like to soften downstream competition and thereby increase, thereby charge quite a high wholesale price to that downstream rival. Doesn't necessarily have to be complete foreclosure, but clearly it would benefit from if that downstream firm somehow would produce less, which it would if it faced a higher wholesale price. Now, that kind of argument in these kind of models that relies, though, on some commitment power by the dominant firm, and these models typically impose quite severe restrictions on, what kind of contracts are allowed or not. And there's this completely separate strand of literature, that was pioneered by two Nobel Prize winners, Oliver Hart and Jean Tirole, and those those models evolve around cozy and commitment problems. The idea here is that if you cannot publicly commit to your contracts, because contracts are typically private information, then actually as an upstream firm you face you would like to behave opportunistically towards your customers, and so then anything like a vertical merger, an exclusive dealing contract, the aim of that is really to restore your market power, your monopoly power. And in a sense, exclusion then is a byproduct of that aim to restore your market power. Now, these models do not rely on commitment power and do not impose contract restrictions, and therefore for an academic like me, there's, would sound actually more appealing somehow. But in antitrust practice, as you probably know, the second strand of literature plays essentially no role whatsoever, whereas it's all typically about this first strand of literature, this raising rivals costs argument, perhaps because these Hart and Tirole models, are viewed as being about really exploitation rather than exclusion, which I think is a little bit misguided, because ultimately any exploitative abuse is ultimately about exploitation, because any abuse is ultimately about exploiting customers. And exclusion is just a way to be able to exploit. It's just a means, but not the aim in itself. So here I think there is a gap, and let me give you sort of a second example of a gap, which I think goes exactly the other way around, where in a sense antitrust practice has taken the intellectual lead over academia, namely the question whether certain practices facilitate anti-competitive behavior by allowing for better coordination within the firm, such as data sharing, for instance. Antitrust practices answered that question in the affirmative. For instance, the case in point is the European Commission's decision to bar Amazon from using marketplace seller data. And similar thinking can be found in Article 6.2 of the DMA. By contrast, IO economists, including myself, we typically, build models, have theories where we view the firm as a black box and don't even think about information flows within the firm. Of course, there's some, cite there, Madsen and Velodi, some forthcoming paper, so there is some academic research now on that topic as well, but I think that's here clearly where academia is lagging behind antitrust practice, and I think where certainly more research is needed. Having said that, is all bad, is, academic antitrust so different from what's being used in actual cases? No, I don't think that's true at all. In general, there's very active exchange of ideas between economists in antitrust practice and in academia. Having said this, it's perhaps less so in Europe than in the US, and that's partly for institutional reasons. I think European competition agencies find it harder to track top economics talent, not least because salaries in the European public sector are quite low. There's less of a tradition of hiring academic economists for short period of time in Europe compared to the US. And even, the European Commission, you might say, is different, of course, in that, we do have our chief competition economist. But even here, I think the institutional setup is far from ideal. In the US, the chief economist of the FTC can just much more deal on the important cases rather than sort of spend his time and effort leading a big hierarchy of economists. That's sort of, in the FTC, in the US agencies, that's done by other people, not by the chief economist. And so I think that allows in the US, and also I think the hiring process is certainly for hiring these chief economists, certainly much better in the US than in Europe, as we have seen, although maybe for different reasons, unfortunately, recently. So I think there are lots, that could and should be improved in Europe when it comes to that. Thank you.
Yeah, thank you, Volker. I think we've come to the end. I just wanted to, not to forget Paula's two challenges to the economists. So perhaps, Volker, you could just briefly respond to those. So she wanted help from economists to show that harm to innovation is harm, and that she wanted to have a quantification of deterrence.
What quantification of the?
Deterrence. What do you got for me?
No pressure. I mean, I think it's certainly very, it's clearly hard, right? I mean, innovation, so this is something that's uncertain, that's much more in the future. So, we just don't, when it comes, for instance, to mergers, just as an example, we understand pretty well what are the short-run price effects of mergers, what are the trade-offs involved. We don't understand as academic economists that well, and partly, there's also not the data really, there's sort of to show clearly, that mergers necessarily harm innovation. Having said this, I think there is the consensus in economics that we think that if the markets are working well in terms of that there is a lot of competition, that this tends to be very good for innovation. So I think what we need to do is just ensure that there is not a monopolization of industries that might harm innovation without necessarily, having to show that there is this harm to innovation. It's just, because that's, so that is hard, I think, to show directly, except, of course, in some cases with killer acquisition. There are sometimes cases where mergers happen, where we know that, the target works on a similar project,
Perhaps,
and, is, yeah.
And perhaps I might stop you just there, because the next panel...
Yeah, Florian is talking
we have Florian on it, who will discuss killer acquisitions. Right. So I think that might be the perfect point. And so I'd like to ask you to applaud the panel. Very good.